Okay, so now that we've completed modules 0 to 7, okay, now we go to the more technical stuff, which is analyzing and answering bar exam questions. So we're practically at the top. We're already here as far as our session is concerned. Okay. You can also go back to that module where we mapped out our bar exam journey. Okay, so at the completion of review, you will be at the summit, ready to take the bar exam. Okay, but you can't go any further. At the top, there is a gatekeeper who awaits you. Okay, and you probably are familiar with the story of the Sphinx and Odysseus encountering the Sphinx, not being able to proceed any further unless he is able to answer the questions of the Sphinx. Okay, so in the same way, the gatekeepers to the legal profession are your bar examiners who will ask you questions to test you on whether you are fit to enter the profession. And so you have to get used to answering their questions. That's really what the bar exams is all about. It's about the ability to answer questions that may be thrown at you. And these questions will be taken from the stuff that you've learned from law school, the basic principles that you need to know as a first-year lawyer. Okay, so as early as now that you're starting your bar review, you should get used to answering questions because this really is what the bar exams are all about. So, some of you maybe are intimidated by the thought of taking a mock bar exam. And it is intimidating to think about sitting down for a half day or a whole day just answering questions. Okay, but how intimidating is it to answer one question a day? When you think about it, you can answer a sample bar question or a past bar question, just one question a day, perhaps in the middle of your review or maybe at the end of the day, just to see if you understand the concept, And if you take one question a day for 1 week, not including rest days, of course, I encourage you to take 1 day off. Okay, so if you answer one question a day for 6 days, you will have covered 6 questions. Multiply that by 4 weeks in a month, so that's 24 questions. And then 24 questions times 7. So that's almost 175 questions, more or less. So by the time you take the bar exams, and we assume it to be in March 2021, if you did this, if you answered one question a day, consistently without fail, you will have done at least almost 175 questions, and that's not even counting the mock bar. Okay, so even if you don't take the mock bar exam, but I still encourage you to do so, if you do one question a day, you will have covered a sufficient number of questions to prepare you for the bar exams. And now, what if you do 2 questions a day? What if you do 3 questions a day? And so, moving up towards mock bar and moving up towards the bar exams, it doesn't become so intimidating anymore. Okay, and so a question a day keeps anxiety away. That's really what it does. It's confidence building, really. The sooner you get used to answering questions, the sooner it also becomes second nature, and it helps you become more comfortable with the whole process of analyzing and answering questions. Okay, and so, with practice makes progress. Okay, until practice makes perfect. So if you just keep at it, if you just keep practicing, you'll get better and better at it until you're finally confident enough to take the bar when the time comes. So what we're going to do for these next few minutes of the module is we're going to be analyzing essay questions. Okay, and so don't be intimidated by this process. We recognize that we're at the starting point, okay, and this is a diagnostic, still part of a diagnostic. You don't have to get the answers right, okay, but what we want to build up today is your ability to identify the right issues, okay? Because if your problem is you don't know the law, you can address that. You have how many months of bar review ahead of you. You have lectures, you have reading, you're going to be doing first reading, second reading, pre-week, you're going to be attending the bar review lectures, you'll be doing mock bar exams. So there are a lot of opportunities for you to strengthen your foundation, to build up your knowledge and your familiarity with the legal concepts. However, if your main issue has to do with other things, such as you're not good at spotting issues, you don't know what the important facts are, or you misinterpret the issues, you're not able to apply the law to the facts properly, or you have poor time management, or you panic easily, or you have bad English. Those are the things that you need to identify as early as now so that you can address them as soon as possible. Okay, and so with this particular session, I hope that you will get enough confidence to answer these questions with me. Okay, we're going to have several essay questions to go through. Okay, and all we're going to do today is we're going to spot issues. Okay, we're going to spot issues. I'm going to walk you through the process as if we're going to effectively slow down the analysis process. Okay, so when you're taking exams, mabilisan yan. You don't have time to deconstruct the process. Today, what we're going to do is I'm going to help you deconstruct it, slow it down, so that you gain the confidence to work through a problem methodically so that you arrive at the right answer. Okay? Now, I'll start out by giving you some guidelines in analyzing essay questions. Okay. First of all, you have to read the problem, and you have to read it very carefully. Okay? Take note of any ideas that occur to you the first time you read it. Okay? And many people make mistakes sa pagbabasa pa lang. Okay? Masyadong nagmadali, nag-jump to conclusions, may mga inassume na wala naman doon. Diba? So the very first act of reading the problem is very, very important. Okay? And note that in this number, I'm not telling you to answer, I'm just telling you to take note first of any ideas that occur to you. Okay, so this is the first view. You read the problem for the first time, certain ideas come to mind, then you have to write them down first upon your first view. Okay? And then, read the problem again, this time more carefully. Okay, so the first time, it's a careful first reading. Second is even more careful. Okay, and you shouldn't start writing your answer until you've read the problem at least twice. Okay, this is my golden rule. Read it at least twice. Because if you just read it once and then you jump to conclusions, there's a tendency that you might have missed something because you weren't very careful when you read it the first time. Now, third thing to look at is what is the question being asked. Okay, and so usually it's a separate paragraph in the whole problem. Is the question, what is the plaintiff's cause of action? That is a different question from, should the plaintiff file a motion to dismiss? Or does the plaintiff have a cause of action? Those are different questions. Even though it's the same subject matter, if the question is different, then it will require a different answer. Okay, so you not only read the problem, but you also read what is asked of you. Okay, pay attention to what is the question being asked. Next, what are the issues that are relevant to the question being asked? Okay, and so this is the point of issue spotting. Okay, so there's a question being asked, and then there are certain issues that have to be drawn out of the problem in order for you to answer that question. What are the material facts? Sometimes the bar examiners will throw in facts which may or may not be relevant, okay, to test whether you know how to make use of those facts. Okay, and we're going to see how this plays out in one of the problems that we'll be discussing today. And then, how do the issues that you've identified earlier relate to the facts? Okay, so now you're going to have an analysis of the issues vis-a-vis the facts, and then bring in the law. What are the applicable legal principles? And legal principles can consist of, the Constitution, statutory law. If this is a PIL question, public international law, treaty, it could be jurisprudence, it could be basic legal concepts, legal maxims, res ipsa loquitur, and so on. Okay, so legal principles, you draw upon the different sources of law. Effectively, what will be the legal basis for your answer? And then, how do these apply to the facts? How do these concepts apply to the issues, and how do they apply to the facts? Okay, and then finally, you have to answer the question. What is the answer to the question? Okay, so these are the 8 steps that we will go through as we analyze these next 3 problems. Okay. So first question, okay, question number 1. Okay. Gerald married Julia at the Philippine Embassy at the Court of St. James in London. At the time of the said wedding, Gerald's marriage to Bea had not been dissolved. Both Gerald and Julia are Filipinos. Can Gerald be prosecuted for bigamy when he comes back to the Philippines? Okay. So I'll give you a few minutes, maybe a couple of minutes for you to think about the question, okay? And then we're going to proceed to analyze, identify the issues, identify the material facts. We won't answer the question, okay? I'm going to leave that to you, okay? But I'm going to guide you through the process of identifying the issues. Okay, so now we're going to do some board work. Okay, so I've projected the problem on the screen. So you've had time to think about it. Okay, so now what we're going to do is we're going to identify the material facts that are in issue. Okay, but first we start out with the question. Okay, so we look at the question. So can Gerald be prosecuted for bigamy when he comes back to the Philippines? Okay, so important thing here is bigamy. Okay, and so we note that bigamy has two components. Okay, bigamy is a crime. So this is an aspect of, this is criminal law. But also it has to do with persons and family relations. Okay, because it has to do with marriage, and so this is civil law. Okay, so this crime has a dual nature to it. Okay, it's a crime that has bearing on marriage and family relations. Okay, next relevant fact. Okay, we see that Gerald and Julia are both Filipino citizens. Okay, and so why is that material? Laws relating to marriage, okay, follow the nationality principle. Okay. And so Filipino nationals, wherever they are in the world, are bound by laws on marriage. Okay? However, we also have to take into account that crime is territorial in nature. And so where the crime was committed becomes material. Okay, so those are two things that we have to consider. Now, is there any other fact here that has a bearing on our answering the problem? Okay, we look at the fact that Gerald was previously married to Bea, okay, and that marriage had not been dissolved. Okay, and so what is bigamy? Bigamy is essentially you're married to two people at the same time. Okay, and so we see that his marriage to Bea had not been dissolved, and therefore he had a prior subsisting marriage at the time he married Julia. Okay, and one other fact that we have to look at, where was the marriage? Where did the wedding take place? It took place at the Philippine Embassy, okay, in London. Okay, so what is the relevance of it taking place in the Philippine Embassy in London? Okay, does it matter that it was specifically at the embassy and not elsewhere in London? Okay, so I won't give you the answer. Okay, but the purpose of this exercise was to point out what is important. Okay, and now I'll leave it to you to formulate your answers to this particular question. Okay, second question. Daniel and Kath got married after living together for 6 years. Okay, if their marriage was solemnized by Mayor Vico Soto at his office, will the marriage be valid even if the marriage license was signed by the secretary of the local civil registrar? Again, think about the question, and we'll proceed to analyze after. So for question number 2, let's take a look at the question. Okay, it's actually a very short question or a very long question since it's only 2 sentences long, this problem. Okay, so anyway, basically it has to do with the validity of the marriage. Okay, is the marriage valid? Okay, and is it valid even if the marriage license was signed by the secretary of the local civil registrar? Okay, but you need to look at the rest of the context. Okay, and so who was the solemnizing officer? Okay, it was Mayor Vico Soto at his office. Okay, and so we presume his office to be in Pasig City. Okay, so something you should know when dealing with facts. Okay, don't assume something that is not there. Okay, and here you have to go with a presumption of regularity. In evidence, you have the context of the concept of presumption of regularity of the performance of official duty. Okay, so if the problem says Mayor Vico Soto was working at his office, okay, we don't assume that he was working from home, diba? We assume that he was working at his office. We take it at face value. We presume his office to be at City Hall in Pasig City. Okay, so the mayor's office in Pasig City. Okay, now, why is that relevant? Diba? You look at the solemnizing officer and you look at his authority to solemnize marriages. And you also look at, is it within his jurisdiction? So we look at the laws relating to authority of solemnizing officers and the requirement that it has to be solemnized within their jurisdiction. Okay, so that's one. Okay. Second is, we look at the marriage license. Okay, and there are rules pertaining to the marriage license. And it was signed by the secretary of the local civil registrar. Okay, now, who is authorized to sign the marriage license? Okay, and if that person is not authorized, okay, so we have to check, is the secretary of the local civil registrar the authorized signatory, or is there some irregularity? Okay, so is there an irregularity? And so, if there is, next question is, what effect will this have on the marriage? So, those are already 2 things we're looking at. We're looking at the solemnizing officer, and we're looking at the regularity or irregularity in the issuance of the marriage license by virtue of it having been signed by the secretary of the local civil registrar. Now, there's also a statement here that says that Danielle and Kath got married after living together for 6 years. Okay, if you were reading this problem only once, diba, you might think, oh, they don't need a marriage license, diba? Diba there's an exception to the marriage license requirement if you've been cohabiting for at least 5 years, diba? So, maybe that's something that occurred to you as you were looking at the problem for this, at the first instance. Okay, but is it really relevant? Maybe not, because even if they didn't need a marriage license, they still had the license anyway. They still applied for it. And so the question is not so much whether they needed one or not in the first place, but whether their marriage is affected by the one that was signed by the secretary to the local civil registrar. Okay. So from there, how would you answer this question? Okay. Now, third and last question. Okay. A known insane person, together with B, a 14-year-old girl, and C, a 16-year-old high school student, stole the cell phone of X worth 35,000 and sold it for 100 pesos. A, B, and C were all charged with theft. Will the charge against them prosper? Explain. Okay, so same instructions, give you a couple of minutes to think about it. Okay, then we'll head back to the board. Okay. For question 3, we have a crim law problem. Okay. And we see 3 people being charged with theft. Okay, so the question is, will the charge against them, the charge of theft, prosper against each one of them? First thing that you need to know, okay, is theft. Diba? What are the essential elements of theft? Okay, so for a crim law exam, it's crucial that you know the essential elements of all of the crimes. And for related crimes, the presence or absence of one particular element could change your answer. Okay, so it's very important for you to be very familiar with all the essential elements and to know the essence of each crime. Okay. Now, after that, we have to look at, will the charge against them prosper? Okay. Do not fall into the trap of thinking that just because the question is phrased this way, collectively, that you have to answer one way for all 3 of them. Okay. That's already automatically the wrong answer. Every time you have different plaintiffs or different accuseds, you should not take them all together, all as one. You have to look at them individually. Okay, I made that fatal mistake before in law school, and I have since learned my lesson. When you have different accuseds, diba, you have to take them one by one, individually. Okay, so let's start with A. Okay, A is a known insane person. Okay, so insanity, okay? What is the implication of insanity in criminal liability? Diba? And what should come to mind? Diba? You have the concept of justifying circumstances, exempting circumstances, aggravating circumstances. Where does insanity fall among those 3? Diba? And note that A is a known insane person. Okay? And so there are certain assumptions that you can already make by the fact that you don't have to prove the insanity anymore. It has already been established by the facts. Okay? So what effect does insanity have on the charge against A? Okay, that's the first thing that you need to settle. Second, we look at B and C, and we note that there are ages that are indicated. B is 14 years old, C is 16 years old. Okay? And so, both are minors. Okay? What law should come to mind? Diba? Are there particular laws that relate to minors and their responsibility under criminal law? Diba? And so you should probably already know the concept of children in conflict with the law, diba? CICL, the Juvenile Welfare Act. Diba? So 2 laws regarding criminal responsibility of juveniles, diba? Juvenile delinquents, that's what they were called before. Now they're called CICLs. Okay? And there was an earlier law and a later law that made amendments. Okay? And so you have to know both rules, and you have to know the latest amendments to the rules on criminal responsibility. Okay? So what is the liability of someone who is 14 years old? Diba? What is the threshold age? Diba? We know that 15 is the cutoff. Diba? 15 is a crucial age. What is the meaning of 15 in this context? Diba? And then if someone is below 15, and then if someone is between 15 to 18, which is the case of C. C is 16 years old. Diba? Is there a difference in treatment between an accused who is below 15, who is B, okay, and an accused who is between 15 to 18, which is C? Okay? So from there, you should already know that there's going to be some slight difference in treatment because they fall into 2 different categories. Now, looking at C, so C is 16 years old, and then there's an additional fact saying that C is a high school student. Okay. Now, what's the relevance of that? Diba? There's a concept in the juvenile justice law, okay, that there's a concept of acting with discernment. Okay, what exactly does that mean? And what exactly does it mean when a child between 15 to 18 has acted with discernment? What is the effect on any criminal liability that they have for acts that they have committed? Okay. Now, there are two facts that you might want to consider in this context. Okay. First is the fact that C is a high school student. Okay. So, may pinag-aralan, presumably, well, edukado to the extent na marunong sa high school. Okay, hindi to batang lansangan na hindi alam kung anong dapat gawin, kung anong tama o mali. Presumably, this person has been educated in right and wrong. Okay, that's one presumption. Okay, there's another fact that might have an effect on your judgment call here. It says that the three of them stole the cell phone worth 35,000 and sold it for 100 pesos. Okay. So which person in his or her right mind would steal a phone that much and sell it for so little? Okay. Does that have any relevance to this case? Okay. Does it have any bearing on acting with discernment? Is that the kind of discernment that is being referred to under the law? Okay. Is it discernment with regard to the cost of the cell phone? Diba? Parang baka bad business people lang itong mga to. Diba? Does it have to do with bad judgment? Or does it have to do with the ability to distinguish between right or wrong? Diba? Is this material to saying that they did not discern properly? Or does the act of discernment pertain to knowing that they should not have stolen the phone in the first place, but they did anyway? Okay, so look at all of that, take those into consideration, and then craft your answer. Again, nuancing between A, B, and C. Will the charge of theft against each one of them prosper? Okay, so now that we've had some practice analyzing the questions, and hopefully you've realized that it's not so daunting, okay, once you slow down the process and you're able to think through the different facts and issues. Okay, now I'll give you some tips on how to answer the essay questions. Okay, so every good answer has 4 L's. First, it has law. Okay, so basically it is based on there's a legal basis, whether it is the Constitution, whether it is statute or jurisprudence. Okay, it has to have the legal basis. It's not enough to say, yes, the petition should be dismissed, or no, the charge of theft will not prosper. You have to cite the legal basis why. Even if you arrive at the correct answer, but there's no legal basis whatsoever, it will probably not receive any points. Okay. Second is, the answer should have logic. Okay, so you have to be able to answer in a logical manner, tying up the issue with the facts, the law, and your final answer. So all of that should be connected, and it should make sense, not only to you, but to the examiner. Okay, remember that you're writing for the examiner, and the examiner should be the logic behind your answer. Okay, and so in a little while, we're going to show you the formula, okay, what your answers should contain, so that you definitely have logic. However way you answer it, if these elements are present, you will have the logic there. Third is language. Let's face it, the bar exams are in English, okay? And so you have to be fluent enough in English, or at least comfortable enough in English, to be able to communicate your ideas effectively, okay? So by this time that you've gone through grade school, high school, college, and law school, you should have sufficient fluency in English to communicate effectively, especially during the bar exams. Okay? And the language comes out in your writing, but also legibility of your penmanship is important. I don't know why the bar exams are still not computerized. Hopefully that they will come soon. But for your bar, you'll have to do it in your own handwriting. Okay, and so that's why in law school you were taught to write legibly, to write in bold, in big strokes, so that even if your handwriting is not that nice, it is legible. Okay, remember that your bar examiners are human, napapagod din, di ba? And if it's hard for them to read your handwriting, they may not have the time or the patience to spend more time on your booklet than for others. Okay, and so to save yourself a headache and to save your examiners a headache, you have to make sure that your penmanship is easily read by them. Now, the ABCs of good legal writing, so in addition to the 4 L's, are A, accuracy. Okay, your answer has to be accurate. You have to cite the right law. You have to cite the right, legal principle. You have to cite an updated, correct case. Okay, it has to be accurate. And remember, when you go back to lessons in legal ethics, professionalism includes reliability, credibility. Your ability to be a good lawyer is hinged on your credibility. Do you know the latest law? Are you honest in what you cite? Can the court rely on you to give them the correct advice? Diba? This is really what accuracy is all about. Okay? They're testing your ability to cite the right law and to be credible in the process. Second is brevity. Okay? It's been said that brevity is the soul of wit, but brevity also is the bread and butter of examiners. Parang brevity means you are short and direct to the point. You don't say in 10 sentences what you can say in 1 or 2. Okay, so you're able to be very short in your answers, but you're able to capture the essence of what needs to be said. Okay, and that is coupled with conciseness. Conciseness is the ability to pack in all the information that's needed in a very, very compact, solid form. Okay, so you have to be brief, but you also have to be comprehensive. But how do you do that? It's through conciseness. Okay, it's finding the right mix of words. It's finding the right legal concepts and making sure that you're able to give a complete answer in the shortest possible amount of words. Okay. So your answers have to be accurate, you have to be brief and straight to the point, and you have to be concise. Now, every good answer should contain the following. First is your answer to the question. Okay? And this is the short answer. So, does the plaintiff have a cause of action? You have to answer right away. Yes, the plaintiff has a cause of action, or no, the plaintiff doesn't have a cause of action. Remember, this is not a novel where you wait until the very end to reveal, who the killer was or, how the love story ends. You have to give the answer at the beginning. Okay, so don't keep your bar examiner guessing. You have to give the short answer to the question immediately. Okay? And the answer is also repeated at the end of your answer. Okay, just as a conclusion. Okay, so the second thing that your answer should contain is the legal basis. Okay, so one of the first L of the 4 L's, you need to have a legal basis for your answer. And the third is your analysis. The analysis is the application of the law to the facts of the problem. Okay, you have to show that in 2 to 3 sentences, that you're able to connect the law to the facts. Now, here's the formula that we recommend. Okay, in other places, it's called ALAC or called IRAC. Diba? We'd like to call it clear. Okay, a clear answer will consist of the following. Okay, first, you will have the conclusion. Okay, this is the short answer. Okay, this is the first sentence of your answer. Okay, the conclusion. You give away the ending right away so that the examiner isn't guessing. The second is you must provide the legal basis. Okay, so you have to cite the law, you have to cite the legal doctrine that is applicable to this case. And so it can be, again, statute, it can be jurisprudence, it can be treaty, okay? Or sometimes it could be justice and equity if for whatever reason you're unable to cite something more specific, okay? But there has to be a legal basis, okay? Now, in case there's an exception to the general rule, okay, and in case this particular problem requires the application of the exception, then this comes in. E stands for exception. Okay. Again, mention it only if it applies. If it does not apply in this case, it's going to be an extraneous statement that does not have to be included in your answer. Now, A stands for analysis or application of the law to the facts. And fifth, R is restatement of the conclusion. Okay, so clear, Again, conclusion, legal basis, exception to the general rule if it applies, analysis or application of the law to the facts, and restatement of the conclusion. Okay. Now, some common pitfalls that we've observed over the years, during the bar exams, and also our students, students make the same mistakes when they answer exam questions in law school. Okay. So, and you may have encountered these sometime along the way. Okay. First pitfall, most common, obviously wrong answers. Okay, so you cited the wrong answer. Okay, and this might be because of a lack of knowledge, di kayo nakapag-aral, or hindi mo alam yung sagot, nag-mental blackout ka, or nag-mental blank ka, or maybe you spotted the wrong issues and you cited something else. Okay, and you ended up giving the wrong answer because of the wrong issue spotted. Okay, so that's one of the most common pitfalls. Okay, second, answers that are too long. Sometimes, parang some people will just answer in a very, very long-winded way, diba? And it may seem na marami silang alam, but when you look at it, the fact na ang haba-haba ng sagot, as parang hindi pa tinutumbok kung ano talaga yung sagot, it just shows that the person answering is unable to go to the heart of the matter, unable to zero in on what is most important. And so, parang parang obfuscation. Di ba? Sinusubukang, parang i-impress yung examiner na parang ang dami niyang alam. Di ba? But if you see really, really good answers, sometimes you only need 3 or 4 sentences and the examiner already knows that, yes, this person has the right answer. Diba? So that's where brevity and conciseness come in. If you know the right answer and you know how to express it, you don't have to say very much in order for the person to get it. If you have a tendency to write very, very long answers, start to think about why is that so. Diba? Chances are, baka hindi kayo marunong tumumbok dun sa most important essence of the question. Diba? So you have to learn how to go to the heart of the matter. Another common pitfall, this time is the opposite, answers that are too short. Okay, too short because they fail to apply the law to the facts. So sometimes I've seen this. People will say, for example, the civil code provides ... and it applies in this case. And then titigil na lang dun. And it's like, no, it doesn't work that way. Diba? You have to learn to apply the law to the facts, diba? And I don't know if it's katamaran or I don't know if it's hindi marunong yung mga tao, but the facts are there for a purpose. Parang if the examiner just wanted to test whether you know this particular provision of law, then they would have phrased it a different way, or they would have asked you to answer an objective question. But if they give you a fact pattern and they ask you a question, the expectation is that you will analyze the facts and apply the law to the facts. Okay, so it's not enough for you to say that it's in the facts or the law applies to the facts. You have to demonstrate to the examiner that you do know what you're talking about. Okay, so you have to spend time explaining how the law applies to the facts. Okay. Another common pitfall is inconsistency between the short answer at the start of the page, okay, and your conclusion. Okay, and how does this happen? Chances are the person who was answering was doing a train of consciousness or stream of consciousness kind of answering. Na parang hindi pa niya pinag-isipan ng mahusay, nagsimula na siya magsulat, and in the process ng pagsusulat niya, na-realize, ay, iba pala yung sagot ko. So nagbago midway yung sagot, and you can tell because kung saan siya nagsimula is very different from kung saan siya nagtapos. In a way, you should think of your answer as like closing the circle. You start at this point, and therefore you should end at the same point. Stream of consciousness answering is you start here and then you end here. Okay, and so obviously that's not correct. Parang at the very least, it seems that you're indecisive with regard to your answer. In which case, you definitely won't get full points because hindi solid yung sagot mo. Now, other common pitfalls outside of the answer itself include running out of time. So poor time management. A lot of people, are concerned about what do I do if I run out of time, diba? And the thing is, you have to prevent it before it starts. Okay, and so we're going to give you tips on how you can manage your time properly. Related pitfall is erasures. Answering too hastily. And when you realize na mali yung sagot ninyo, you have to erase and you have to redo your answer. Again, prevention is the best, is the best cure for this. You have to prevent erasures by writing your answers down only when you're really very sure about it. Okay, you minimize the possibility of erasures if you think your answers through and you provide outlines beforehand. Okay. And then poor English, unfortunately, is one of the most, I think this is the biggest problem of examiners from time immemorial. Every year, the bar chair, the bar examiners will report that so many people fail the bar because of poor English. Okay, and it's not just small grammatical errors. It's like very, very serious lapses in English. Again, the injustice of the bar exams being in English, even though it's a foreign language to us. But that is the reality of our situation. If you don't have a mastery of the English language, you have to identify it as early as now so that you can get help. This is something that we're looking at for our incoming freshman students, trying to find out who needs help with English, because it's possible to correct it. I have seen students in first year who had really, really bad English. I wondered how they got into law school, but they were obviously smart. And, talked to them and told them, guys, you need to work on your English. Ayun, yung dalawa who come to mind, sa awa ng Diyos, they graduated this year. One of them was even an honor student. And significant yung improvement in English. Okay, so it can be done. Just because you don't have good English at this point doesn't mean that it's fatal. But you really have to work at it. You really have to work at it. And so if you need help, you need to get help as soon as possible. This is something that has really been the major stumbling block of so many bar examinees, thousands, perhaps tens of thousands. Okay, if you don't want to be a casualty, you have to address this. Okay, so please be very realistic about this if this is one of your Waterloos. Okay, and a related Waterloo is handwriting. If you have poor or illegible handwriting, again, it is not fatal. A good friend of mine was placed number 2 in the bar in 2004. Even though he himself admitted that he has atrocious handwriting, he was shocked to have placed in the top 10. But, obviously, he was able to fix his handwriting well enough in order to make it. Okay, so if your handwriting is poor, start practicing. One of the most practical ways of making it legible is by making the strokes bigger. Okay, one of my mentees last year, a very smart guy, he had bad handwriting, and the way to solve it was to increase the strokes, to make it larger. Ayun, pumasa naman. Yun. Okay, so how do we avoid these 8 pitfalls? So first tip that we give you, okay, and this is in relation to the exam itself. Okay, read the entire exam questionnaire from start to end, okay, during the first 20 to 30 minutes of the exam. Okay, why is this important? Okay, we go back to our Mount Everest metaphor. Okay, you don't set off on a climb for Mount Everest unless you know the entire journey. You have to know exactly how many miles you're going, how many days it's going to take, how many oxygen tanks you need to bring, diba? And you only can do that if you know the whole situation. In the case of the exam, you can only know how difficult the exam is if you read everything from first page to last page at the start. Okay, and then when you do that, make initial notes on the questionnaire. You're allowed to write on the questionnaire. Okay, yan yung scratch paper ninyo. Don't make the mistake of writing on your blue book. Okay, baka ma-consider marking or something. You don't want to tear out pages. Okay, but you are allowed to write on the questionnaire. Okay, make initial notes when you read the questions. Okay, take note of what questions you can already answer and those which require more thought. Okay, And also, from there, you'll be able to budget your time for the rest of the exam accordingly. Okay. So usually, from previous experience, the bar exams have 20 questions at least per field of law. So isipin nyo, political law is 20 questions. Sometimes they'll have sub-questions like number 5A and B, etc. Okay, but generally the average is 20 questions. So 4 hours divided by 20. Okay, that's your average. But then there will be questions that you know, which you will answer in less time, and those which you don't know, which you might require a little more time to think. Okay, and so the only way to budget it properly is if you're able to identify already which ones you know, which ones you kinda know, and which ones you don't. Okay. Now, if you don't know the answer to a question, okay, do not panic. Okay, do not panic. Calmly move on to the next question. Okay, and you have to know this. The first question of the first day of the first exam, okay, tends to be very tricky or tends to be very difficult. One classic example of this was the 1995 bar exam, political law. The very first question that was asked was, what is the writ of amparo? Note that this was in 1995. The writ of amparo was virtually unknown anywhere else outside of Latin America. Okay, how did it end up in a bar question? Justice Ascuna had come from a conference abroad and had heard about the writ of amparo, and he was so impressed with this particular legal instrument that he decided to ask it in the bar exams. And it's like, if you were taking that bar that year, and you saw that question, and you panicked, baka nawala na kayo ng loob for the rest of the exam. Okay? And there are many people like that. My father was telling me during his bar exam that someone, a Batanggenyo, from the accent, just lost it when he saw the first question. It's like, ano ini? And he got up on his table and started reciting the Constitution, and had to be taken down and carried away, or at least, dragged away by, Supreme Court personnel. He was so rattled by that first question, he couldn't answer it, and you don't want to become a cautionary tale like those people, okay? So be prepared for questions that you cannot answer at first glance, okay? Do not panic, okay? Move on to the next question, okay? Move on to the next question. And the thing is, you can be assured that somehow, you'll be able to remember something that will allow you to answer those questions that you were not able to answer the first time. Okay, so don't panic. Manage your stress. Make sure that you remain in control the whole time. You will find something in the rest of the exam that will trigger your memory and allow you to answer that question that you had to skip. Okay. Now, read each question carefully at least twice before proceeding to write down your answer. Okay. Make sure to read it carefully at least twice before proceeding to write down. And before writing down your answer, make sure to outline your answer, okay, clearly. Okay. Use the clear outline, okay, before you proceed to finalize, okay? And again, write the outline on your questionnaire, not on your blue book. We want to minimize erasures, okay? So some law schools, I hear that UST prohibits erasures in their exam booklets because they want to prepare their students adequately for the bar. So in the same way, one way of preventing erasures is by making sure that you're very clear on the answer before you proceed to write it down. Okay. When you're clear, you minimize the need for erasures. You minimize the likelihood of having to tear out a page or, use up a different page for another answer. Okay. Try to get it right the first time. Now, answer only one question per page. Okay. Always start a new page for a new question. Okay. What's the reason for that? So relating it to the issue of erasures. Okay. Palagay natin na nagkamali kayo. And you have to replace your first answer. Despite your best efforts, despite the fact na nag-outline ka, you realized eventually na mali yung sagot ninyo. Okay. By answering only one question per page, you might be able to still have space on the bottom of the page to write your new answer. Okay? So ipalagay natin na there's space. Okay? That's why it's important for you to limit your answers to just one page of the questionnaire, of the booklet, sorry. Just one page. Anything beyond one page, and when we say one page, it's one sheet of your exam booklet. Anything beyond that is too long, diba? And we did the math. Examiners only will have, 5 or 6 minutes per booklet. 5 to 6 minutes to check each booklet. And if you do the math further, it's probably 30 seconds per question, diba? Ganun kabilis dapat. And so they won't have time to read answers which are 2 or 3 pages long. They'll just assume, hindi nila nakuha yung issue because that could have been answered in half a page. Okay? So if your answers are leaning towards, more than one page, you have to rethink, baka masyadong mahaba yung sagot nyo or hindi niyo natumbok kung ano yung talagang importante. And going back to why it's important to just use one page for your answer, okay? In case you have to redo your answer, you can write at the back. Okay, so use only the right side of your exam booklet. Do not write back to back. Okay, use only the right side. In case you have to redo, you can use the opposite side to write on. Okay, so you have a blank space to write on. Okay, and you're still in the same sequence. One of the things that you shouldn't do also is to reorder the sequence of the questions or of your answers. Diba? Nakakahilo yun sa examiner. At medyo nakakapundi din. Okay, so you have to keep the sequence. Write only one answer per page. Do not write at the back. You can save the back for any contingency measures in case of erasures or having to redo your answers. Okay. Now, when in doubt about a particular question, do not agonize over it. Okay? Maybe you can agonize about it for 3 to 4 minutes, but anything longer than that, kung feeling ninyong hindi ninyo kaya, mag-move on na kayo. The longer you stay on a question that you cannot answer will only result in more frustration, which will result in more anxiety until you panic. Diba? So, you cut your losses. Parang, okay, I can't answer it now, but I can come back to it later. Okay, so leave space for that answer. Make sure you leave one blank page for that. Okay, and move on to the next question. And make sure to come back for it. Okay, so you can mark sa questionnaire ninyo kung ano yung mga nasagutan ninyo. And then also make a notation, come back to this, or don't forget this. Okay, so pwede ninyo lagyan ng question mark yung number na yun to indicate that you have to come back for it. Now, for the sample questions that we have, that we discussed earlier, please do answer the sample questions on Moodle. Okay, so we've converted them into quizzes so that you can answer them. Okay, and please do submit them. These are going to be diagnostics that will help us identify, what you need to work on, diba? If you're able to answer it properly, then well and good, that's fine. But the purpose of this exercise really is to see if you're able to spot the important issues. Okay, and note, this isn't a timed exercise, so you have, you can read up on it, you can research on it. Okay, what we're really trying to identify here at this stage is your ability to analyze, to identify the material facts, to identify the legal issues, and to come up with an answer that is correct. Okay, so again, I'd like to reiterate the request that please do answer one question at least a day, so that you get used to the habit of answering questions, and don't be afraid of answering questions. That's the way to befriend the gatekeepers who stand between you and the legal profession. Okay, and so when you take the bar exams, remember, the gatekeepers will let you in if you can answer their questions. Okay, so as early as now, do not let the questions be a threat. They are your friend. And the sooner you befriend them, the easier it will be for you to enter through the gates. And so with that, that concludes our session. Thank you very much for the opportunity to be with you, to help you prepare. And always feel free to come back to these lectures and to fill out the handouts whenever as you go along this journey. I wish you all the best, and I look forward to seeing you in person, hopefully, within the next few months. If you have any questions in the meantime, feel free to drop me a line through the forum, and I'll be happy to answer whatever questions and help you out in whatever way within the next few months. So all the best, good luck, God bless, and padayon.